Welcome to the Order on Family Time, a training program for those who will be involved in the piloting of the Order on Family Time in 3 different jurisdictions in New Mexico. And this is the work of the Children's Court Improvement Commission and specifically the Enhanced Family Supports Work Group. As a result of today's presentation, you're all going to gain some insight into the relationship between meaningful family time and the importance of maintaining safe and healthy connections to family, which of course includes siblings, extended family, aunties, uncles, fictive kin, and of course, pets who may be a significant part of a child or a whole family's life. We're all going to acquire additional understanding of the relationship between what exactly meaningful family time is and the time to permanency, how that impacts permanency sooner rather than later. We're also going to learn about the Order on Family Time, the template that we'll review later. And that's a template for meaningful family time advocacy at each stage of the case, beginning certainly at the custody hearing and some planning that goes into that Order on Family Time even before the custody hearing. We're all going to take an opportunity to evaluate the Order on Family Time as a measure of the department's requirement to make reasonable efforts and in IFPA-ICWA cases, active efforts to implement meaningful family time as a critical component of the family's case plan and permanency, again, sooner rather than later. So a little bit of background about how this Order on Family Time came around and the whole Enhanced Supports to Families effort of the Children's Court Improvement Commission. In the fall or winter of 2020, somewhere around there, the Children's Court Improvement Commission strategic plan included a proposal or considered a proposal to CCIC to develop cross-system approaches to providing enhanced supports to families. How do we engage families in a better way, not just the parents who are those who are alleged to have abused or neglected their children, but the entire family, including, of course, the children and other extended family members. So part of the strategic plan also had as another goal expediting permanency. And the reason for that is to reduce children's time in foster care by providing supports that would enhance families' experience in the child welfare system and to have the result of a desired outcome for safe reunification or some other form of permanency. So one of the objectives also was, how do we expedite family time, not just from the standpoint of the department or from the court, or the attorneys representing children and attorneys representing parents, but the whole system's involvement, including, of course, community providers that work with the families. Who all was involved in this work group? Well, there were representatives from who represent youth, and there were youth who'd been through the process. We also had parents who had been through the process, those with lived experience, or as I prefer to say, lived expertise, because after all, they are the experts of what worked for them and what didn't. The resource parents, formerly referred to as foster parents and still referred that way, but made up, part of the work group included youth, parents, and of course, resource parents. We had a CASA representative in the group that provided valuable input. And of course, the Children, Youth, and Families Department was represented as the whole family time order and what it would involve. They were involved as well. Of course, attorneys from those who represented parents in the child welfare system and guardians ad litem and youth attorneys who represented, of course, their charges in the system. There were some judges involved, and we also had the opportunity to have tribal partners involved in the work group. And it was important because that tribal partners be involved, because Native American families are involved in our system, but very importantly, with the upholding of the Federal Indian Child Welfare Act still impacting what we do, and also very importantly, the Indian Family Protection Act, which we're now in the second year of figuring out how that works and ensuring that the spirit and the intent of IFPA is what we're working around, not just the letter of the law, but take some time to review IFPA and see how it's different from the federal ICWA and how the input of tribal members is important, and how respecting them and ensuring that we're not minimizing their participation and the value of what they bring to the table. Because if it's about their families, their communities, it is critical that we pay attention to what they have to offer and also to what they offer as solutions to what's going on. The order on family time and how that enhances families' participation and a move toward permanency was not just something that we dreamed up, but was based on research and policies that are in place or being put in place in other parts of the country. Very significant was the Georgia Family Time Practice Guide, which is a very extensive and well-researched document that has been in progress for, if I remember correctly, well over 11 years. It is still a work in progress as far as implementing it in every county in the state of Georgia. In Nebraska, they called it parenting time. Same thing, parents and children, ensuring that parents and children have quality time together. All of the siblings have quality time together throughout the case. And theirs was entitled Guidelines for Parenting Time. So much of the research and the model policies focused on how judges can support reunification. It's important to remember that the child welfare system is a system. It's not just the child welfare department, and it's not just the attorneys who represent participants in the process, but it includes judges. Judges are not just supposed to be, but they are part of the system and are supposed to guide and oversee how everything goes. Quality Parenting Initiative is another component that we should not overlook. Quality Parenting Initiative is a national movement called QPI, as it's also known in New Mexico, is off to a start. And their statement on what Quality Parenting Initiative is supposed to be like in New Mexico is about cultivating trusted partnerships, emphasis on partnerships. That means resource parents, families of origin, the children involved, but cultivating trusted partnerships throughout the system by treating everyone with respect and compassion, providing clear expectations, and you can't do that unless you engage in conversation and understand what other people bring to the table and what works for them, not just dictating what's going to happen. But part of the brand statement for New Mexico QPI is we're to honor culture, and we're putting children, very importantly, in the center of our relationships, not using them as tools or pawns to wage battle against each other, but putting children in the center of all of our relationships to ensure that they receive excellent parenting from the resource parents while they're in out-of-home care, not at the exclusion of their family of origin, but including their biological parents in the whole process, so that we can ensure that excellent parenting and daily love is provided for these children in what they're experiencing throughout their time in.
Okay, for engagement and connections with families and children, research shows us that children participating in more frequent and regular time with parents have positive outcomes in foster care and overall. They have stronger attachments to their parents. They have improved child well-being in all areas, education, medical. They have fewer behavioral problems, which supports kids being stable in placements. There's lower levels of depression, which supports kids not being on medications, and just better adjustment, both to moving into the foster care system as well as transitioning home. This connects and develops relationships with families and children and youth with relatives outside of their placement. So encouraging family time to be with not only mom and dad, but also with grandparents, aunts, cousins, really supports those connections to children outside of their immediate family. Family time is a fundamental right for all children and youth in foster care. And this is what our CFSR reviews really tell us, that we need to ensure that parents and kids are seeing one another and that it's meaningful and quality time. And it is well established that more frequent or more family time results in shorter time in care. Those kids are going home within those 12 months that our children's services reviews require.
So more about the research and best practices involving family time. And it's pretty resounding that we need research to tell us what we all should know. And that is that the relationship between a mom and dad and their kiddos is one of the most important things we need to be concerned about in our child welfare system. The relationship is paramount between parent and child. Family time is critical to maintaining, protecting, and strengthening the parent-child relationship, not just when the child is in their home, but very importantly, when the child is in out-of-home care and involved in our system. We should not assume that just because a child has been removed and is in out-of-home care, that at the very beginning, family time should be supervised. That's a bad assumption. If we're going to order that family time be supervised, we need to know why. And that should be on the record and included in a written order. I'm sorry, go ahead, Cantrell.
So increasing the value of family relationships and maintaining those family and sibling connections also increases placement stability. It improves well-being and outcomes for all children and families. And this is just important to remember because we do have children moving, and ensuring that they have good relationships with family also supports our QPI, right? Co-parenting between our resource parents and our bio parents. Improving and identifying the supports to these family time supports and to parents helps. Having resources, training for those who may be visit hosting, identifying what those barriers are and supporting those, or finding areas where we can support in minimizing those barriers for all of those interested parties to improve and support that family time. Humanizing this experience, when we can talk about why does this visit have to be supervised, and can it be outside in the community? Can it be at the foster home? Can it be at mom's home? Could it be at auntie's home or grandma's home? That really supports. It is so uncomfortable to be in the visit rooms at the CYFD office. It's clinical and it doesn't really support a natural family setting. Family time should also not be used as a case compliance, either reward or consequence. So ensuring that all of our youth and our children and our parents are seeing one another, regardless of what's happening in their case, is really paramount. Ensuring that, parents might be have tested positive for a UA, but ensuring that it's not a safety concern with them during a visit. Even if they haven't gone and done their therapies or gone and seen the kid at the treatment team meetings, that they still can have family time with their child. A phone call, a video visit, anything.
So if I may add just very quickly on the second to the last bullet point, humanizing the experience. It was my experience that when we had folks who were clearly distinct from what we're used to, that perhaps we didn't tune into that culture, whether it was our Native American brethren or whether it was folks from other countries, we tended to move on with business as usual. Humanizing the experience means understanding the culture and giving them the respect and the dignity in our process that we are all entitled to. Thank you.
So discussing family time as a team on this new order, we are encouraging everybody to have those discussions prior to going to court. So everybody is on the same page, meaning respondents counsel, GALs, youth attorneys, the social worker or PPW assigned to the case, parents, any possible relatives that could be visit hosting, all of that. So at an initial assessment planning conference with youth and parents and legal counsel, this should be discussed, talking about what are the worries during the visit so parents truly know what are they watching for, what are they looking for, what do they think is going to happen at these visits, what can parents do to show that they can mitigate these worries, what can they do to show us that this should not be a worry for us. During these visits, even if you have to have some supervision, what can parents do to show you that they can be unsupervised sooner rather than later? Could a visit host help? Could grandma picking kiddos up and taking them to Dion's and being there with mom and dad and having dinner and then taking them back be a possibility for unsupervised contact or if supervision is needed? Could a sandwich visit be that? You know, checking in when mom picks up kids and then checking back in when she drops them off. Could that be something that happens in lieu of supervising the entire time? How do we support transportation and location to this family time? Is there an alternative form of transportation that could be done? Could grandma drop off and pick up? Could resource parents drop off and pick up? Those types of things. And then who else can help? Are there other people that the kids trust and can support this? You know, there might be stepdad in the case. Could his parents support, even if they're not visiting, but could they transport for mom and dad? Those types of things, and talking about all of that. Where are these visits going to be and who's allowed to come? How often should we reassess family time and how often should this order be drafted? I think every time that you're talking about moving a case forward, anytime there's an IPM or an individualized planning process meeting for youth, a family-centered meeting, those are all different times. At a pre-adjudicatory conference, talking about those. Do respondent or GAL or youth attorneys know what alternatives to supervised family time could be? Those things like the visit hosting or sandwich visits. Can you guys talk about those? What other things could happen for a family? You know, does the CYFD office next to a park? Could the parents just go across the way to the park? Those types of things and thinking outside of the box. What are reasons that this plan or order could change? Really talking about those things. Could this visit host not be working? What are those things that could show progress for a parent in ensuring that they get to have more time with their children? And what about incarcerated parents? What are some of those alternatives that we have for them? You know, talking about that Get Out app. Could they have some family FaceTime? And how can we ensure that happens? Would the foster parents be willing to register on there? Is there another relative that can pick up the children and have those video visits with them? Are we supporting phone calls and letters back and forth with incarcerated parents? Are kids able to send the worker with some of their drawings or other things within, and that could encourage more family time? And so talking about icebreakers, this is also part of our QPI process. So Judge Romero talked about the QPI model and co-parenting. How do we start that process off? As soon as a child or youth comes into foster care, we want to set up a meeting that could be facilitated by the worker, could be facilitated by an investigator or PPW, to really talk and focus with parents. This is an opportunity for the parents to say, who are you? What does your home look like? Do you have pets in there? Who's going to be taking care of my children? Can I tell you about my kids? This is what they like to eat. This is what they don't. She really likes to brush her teeth in the morning, but doesn't at night. And so this is how I have to do it with her. This is the types of meals that they like. Those types of questions that they can have answered. If there's things about school that parents really want to talk about, you know, she really struggles in math, or he really wants to be in band, those types of things, and talking about that. with families. This icebreaker should occur anytime a child moves placements. Not only with the prior placement should it occur, but also again with the parents so that they know where kids are going. This icebreaker should occur within, close to 24 to 48 hours as soon as the child comes into custody. This is really a model that we at CYFD have grasped and called bridging the gap, and talking about collaboration and how do we co-parent with our resource parents and our parents so that we invite a culture that they're utilizing one another when they need extra support. And that kid goes home, can mom call the foster mom and say, hey, she's sick again. Did she get sick like this? What did you do? And how did you help her? Those types of things.
Hello, everyone. My name is Alma Roberson. I'm a children's court judge in the 2nd Judicial District. I also serve on the Enhanced Family Supports Work Group of the Children's Court Improvement Commission. As stated by Judge Romero, the idea for this order stemmed from conversations about improving family time and elevating the advocacy and judicial oversight surrounding how and when parents get to see their children. The order was not created to be used against parents and families, and we tried to make that clear in the order, as you'll see in just a minute. If you're watching this video, it's likely that your jurisdiction is taking part of the Family Time Order pilot project. Several judicial districts across New Mexico will serve as test sites for this Family Time Order. The ultimate goal of this pilot project is to shorten time to permanency by improving the quality of time spent between parents and their children. I'm going to share the order now. This order should be addressed at every hearing, starting with the custody hearing. At the inception of this pilot project, the judicial officers will fill out the order and file into the record. The court's expectation is that parties, in collaboration with tribal partners, will review the order outside of court so that they may be ready to state any stipulations or positions when asked by judicial officer. The judicial officer will make findings under number 1 through 5 for each respondent as needed. It may be that the information is the same for each respondent, in which case that should be clearly noted in the order. That can be done by listing each respondent in number 1, right here. If the findings in the family time order vary for each respondent, parts of the order can easily be copied and pasted. The court will make findings on whether family time is to be supervised or unsupervised. If unsupervised, any limitations to that should be clearly noted on the order. For example, not allowing the child to be transported by the parent or requiring a parent with unsupervised family time to not allow unsupervised contact with another parent. If the court orders supervised family time, it is important that the reason why supervised is necessary is clearly stated. We want parents to understand what the concerns are so that they can address these issues, which leads to 1A. What does the parent need to do to address any concern? What behaviors need to be demonstrated by the parent? That should be answered in 1A. For section 1B of the order, please keep in mind that a family time host may be different than the person supervising. Family time may be hosted by a cousin but supervised by grandma. There are also different levels of supervision. For example, some situations may require direct supervision at all times. Others may only require that a designated person be nearby and within earshot. Number 2 of the order addresses where family time shall take place, perhaps a park or a mall or a family member's home. Number 2 allows for any agreed upon changes to the location to take place by stipulation of the parties. These options were created in order to ensure that everyone, including judicial officers, are intentionally considering alternatives that would make family time more natural and meaningful for children and parents, guardians, and custodians. Number 3 outlines the frequency and length of family time. Number 4 asks parties to communicate about any potential transportation issues ahead of the scheduled family time, and also requires a finding identifying how children will be transported to family time and what resources exist for parents to address any transportation issues. Number 5 addresses icebreakers. As explained by Ms. Mosley, these icebreaker meetings provide an opportunity for parents and resource parents to share information about the care of the child. These icebreakers should be happening when the child first enters custody and after every new change of placement. Number 5 ensures that the icebreaker is addressed in court. Number 6 explains that the order may be changed at any time if there is a stipulation. Those changes should be reduced to writing in this order and submitted to the court for approval. Number 7 explains that the department may change the family time outlined in the order on a short-term basis, not to exceed 1 month. Any changes longer than that require a meeting between the parties to discuss the changes. If an agreement cannot be reached, the department is to file a motion outlining its reason for the change, details on how the department has collaborated with parents, resource parents, and the children's tribe or pueblo up to that point. But of course, any party can file a motion to address family time as stated in number 8 of the order. Number 9 calls for specific findings on IFPA cases to ensure that the best interest of the Indian child were considered and that the tribal representative or IFPA worker were involved in creating the family time plan. If there was no input from a tribal representative or IFPA worker, the court must consider the critical importance to the Indian child of establishing, developing, or maintaining a political, cultural, social, and spiritual relationship with the Indian child's tribe and tribal community, and with a familial ties such as clanship and family with unique cultural characteristics pursuant to Chapter 32A-2836C of IFPA. The court must consider these factors and make a finding on how they are being incorporated into the family plan. Number 10 states that more family time can be added to the plan by the department, and number 11 explains the purpose for the order and also clearly states what is not the purpose of the order. The order is not intended to be used against parents and is not intended to be used to make findings of the family's compliance with their case plan. Family time is a very important factor for the court to consider when making big decisions. That is not to say that the family time cannot be testified to in a termination of parental rights trial, as it usually is, but this order should not be weaponized in any way. Again, this order is a result of collaborative efforts between practitioners, judges, CYFD, and the community to better the outcomes for our children and families by increasing the quality of family time. With that, I'm going to check in with Judge Romero or Ms. Mosley if they have anything to add.
Cantrell, anything you wish to add?
No.
I just, want to thank you all for taking the time to view this video. The pilot program will be very important in giving us a direction about what needs to be changed in the order, if anything, and how we can make it all better so that the whole state can begin using it. I want to underscore again what Judge Roberson just finished talking about a while ago with regard to the Indian Family Protection Act and the best interest of an Indian child. We talk about best interest a lot in the work that we do, and it shouldn't be a generic phrase. Remember that to show honor and respect to the different cultures, especially our native cultures in New Mexico, IFPA gives us some very clear direction on what the best interests of an Indian child would be that may be different from other situations. Although I would argue that the best interests outlined in both ICWA and IFPA should be applied in every case when it's at all possible. Thank you all very much.